Okay, now this is part 2 of Carl Miller's constitutional argument explained. Let me first say that I am not an attorney. This is not legal advice. We're talking about the law here. This is common law, and I'm a man talking to other men and women. Now, and let me say that this video is to explain what Carl Miller is trying to explain to us. I am not telling anyone to do anything. I'm not asking anyone to break the law. I'm simply having a constitutional discussion about the law. So now let's go into this. What Carl Miller said here is, now let me give you an example in today's timing as how effective this is. This argument is so effective that it literally nullifies the Brady Bill. And the Brady Bill is what made it mandatory in the United States for people to have to get a background check and have to wait 5 days to receive their firearm. That's what the Brady Bill created. And let me first say that it's a difference between the United States and non-United States. I understand that. We'll talk on that later. Now it says, it nullifies the crime bill that takes away the right of the people to keep and bear arms. On these 19 weapons that turns into 159 weapons. It stops the 666 bill that just went through that they're trying to take away the Fourth Amendment because they have no power to pass a law that is in conflict with the United States Constitution. It's automatically null and void of law from its inception, not from the day you go to court and brand it as unconstitutional. Okay, you understand that? From the day they passed this bill, it was unconstitutional, not when we go into court and branded unconstitutional and win the case. It's been unconstitutional. You gotta understand that. It's very important. He's trying to run that through to you guys. He's trying to run that through to us. Now, a lot of people think they have to go to court and brand it unconstitutional, but if you know your arguments and can show your arguments, most of the time you'll win. Every now and then you run into a hard nose, but I'll show you how to deal with him too. The next thing I'm going to teach you is about the Second Amendment. The Second Amendment is the one everybody talks about today and the one that probably gets railroaded the most. The next is the Fourth Amendment and the Fifth Amendment. The Second Amendment is the one of the most vital amendments here because our forefathers had such an important understanding of life, liberty, and the pursuit of happiness. That was the First Amendment. That they turned around and realized without that right to protect the first right, they don't have the right. So the Second Amendment, they instituted the right of people to keep and carry arms, and that right shall not be infringed. Now, they started out by saying a well-regulated militia being necessary for the maintenance of a free state. Now, that's just a true statement, okay? That's just a true statement, but the most important part, it doesn't mean that you have to be part of a militia to exercise this right, but the most important part about the Second Amendment is where it says the right of the people. And the Supreme Court has ruled in hundreds of cases that whenever it says the right of the people, it means the right of each and every single, I'm going to say, man to possess the right equally. And when you say man, it means mankind. This Carl Miller uses the word citizen, but his argument is going in the point where we're pretending that the Act of 1871 didn't happen. We're acting like the Constitution is valid, basically. We're playing the game with them. This is how Carl Miller's argument is, okay? We're playing that game. It's not a true common law procedure. Just to let people know that. That's why I refer people to Carl Lentz, so they can get a better understanding. In theory, Carl Lentz works better. But I guess in practice, Carl Miller's argument is the way to go. Now, a lot of guys like to hand out this Manola. Well, that's a collective right. You have to be a member of the militia. That's all who done, says Carl Miller, right? You don't have to be a member of the militia. All you have to do is be an American. You have the right. You have the right to keep and carry arms, and that right shall not be infringed. Now, he was absolutely right when he said this in the 90s. Because right here in 2016, the United States Supreme Court ruled just that. And here we have it right here. Oh, sorry, 2008. District of Columbia versus Heller, 554 U.S. 570, 2008. You can find different wording. It says private citizens. I don't like using the word citizens, like I said before. It says private citizens have the right under the Second Amendment to possess an ordinary type of weapon and to use it for lawful, historically established situations such as self-defense in a home, even when there is no relationship to a local militia. No militia is needed, just like Carmelo said, right? All those years ago. Here it goes again on Bill of Rights Institution.org. Heller versus District of Columbia. The Supreme Court handed down a landmark ruling at the end of last year's term, it's from 2008, with the case District of Columbia versus Heller. Richard Heller challenged the district's law banning virtually all handguns on Second Amendment grounds. The court agreed with Heller, finding the ban unconstitutional and holding that the Second Amendment protects an individual's right to keep suitable weapons at home for self-defense unconnected to the militia service. Now, what does that mean? The whole bill is unconstitutional. Who says so? We say so, right? What backs that up? Article 6, Paragraph 2. Marbury versus Madison, 5 U.S. 137. Anything in conflict is null and void the law, right? Now let's continue, right? On page 7. Now, note after infringe, there is no subparagraph A, B, C, D, E, which would stipulate that would be an acceptable infringement. So all infringement is forbidden. They can't do anything that is in conflict. I asked them, what is it that you don't understand about the word infringement? Because that's what it says when you look it up in Black's Law Dictionary. When you want to talk to these people in the court, you want to have a Black's Law Dictionary. You would be absolutely amazed what's in the Black's Law Dictionary. These are the exact words that you need to be able to definitively define the word game problem we are having with these people today. And it's still going on now, even from the 90s all the way to today. And he's talking about legalese. Alright? This is the language of the courts. I did a video about it a while ago when I first started my channel. At an Expose Evil channel. Legalese, the specialized or technical language of the legal profession, especially when considered to be complex or abstruse. A style of writing or speaking heavily emphasizes the abstruse technical vocabulary of the law to a point where the speech or document may be incomprehensible to non-specialists. The technical talk of the legal profession, right? Now this is not common law. Legalese is, maritime amnesty law. It's the Babylonian Code. It's a language that looks and sounds like English, but has totally different definitions. Literally, if you look in my older videos on the Expose Evil channel, you will see that a lot of words have opposite meanings to what we think they mean. So, like, for example, must in regular common English means that you have to do something. But in legalese, must is a non-mandatory word. It actually means the same thing as shall. And then shall has a mandatory effect in legalese. It's very twisted. Go look at my older videos so you can have a better understanding of that. So back to page 7. They keep changing the words, but guess what? The words in this book are the words that were written when we were in the Constitution, when it was signed. And the definitions that are in this book are enforceable in the court of law. You can bring this book into the court and pull it out open, and pull it open and say, "This is the one, Judge," and they have to listen, and that's the way it is. So for sure, if you're going to be in this, go down to the bookstore or Amazon.com. I like this. Someone put that, whoever edited this, and get a copy of Black's Law Dictionary. You need that to be in this because it's like defining the map of how to get to point A to point B. You have to have this book so you can pull it out and say, hey, don't trample on my rights. Another good book on the Constitution you can pick up is American Constitution, put out by West Publishing Company. This goes into a whole lot of white arguments as to your Constitution. Now, after I'm finished talking to you and going to have a new concept of the Constitution and how it works, and you're going to understand it and what you say it is, and it's what you say it is. If you got an honest right, I'll give you an example. Now, the First Amendment basically talks about the right to life, liberty, and the pursuit of happiness. But isn't that the right to work part of the right of life, liberty, and the pursuit of happiness? You got the right to work, right? To contract your labor, your skill, your time, and your life to see the way you see fit. That's the First Amendment, right? Another First Amendment right would be the right to travel freely and unencumbered. No state can require you to have a license to travel freely and unencumbered, and we will go into that to show you how that is taken care of. The bottom line is you need to learn as much as you absolutely possibly can in the shortest possible time about your Constitution, because I'm telling you, right now, as we speak, they're trying to curtail that Constitution and take away our rights that have been given to you by your forefathers. Now, Carmelo was absolutely right. If you see all these bills that have been passed that are trampling all over our rights, simple stop and frisk in New York, it's right next to me, next state over. It's crazy. There's only two things that are going to stop that. The first thing is that we all get together and get a hold of the Constitution and start shaking it. Say, whoa, horsey, we're not letting you take away that Constitution. This is America, and we got an American flag on that pole out front. Yeah, Almaty flag, I don't know about all that, Carl. You know, flags are corporate logos. It's like pirate ships. They represent corporations. So, last time I checked, this is America, and we got a Constitution. Here you got, and you ain't touching that Constitution. The second way we can do it is necessary and proper in our armed militia, and can come together and decide to tell these people that they are giving aid and comfort to their enemies of our country. By breaking the laws, you have broken the law of Title 18 U.S. Code Section 2381, which says, when in the pursuance of two witnesses to the same overt act in an open court of law, if you fail to timely move to protect and defend the Constitution of the United States and honor your oath of office, is subject to charge of capital felony treason, and upon conviction you will be taken to pole's nearest and busiest intersection at high noon, hung by the neck till dead, and the body to remain in a state to dust, as an example to anyone who takes their oath of office lightly. You see, without the oath of office, this Constitution is worthless. That's why we have to take the oath of office, so we know that you will honor that oath of office. Now, let me tell you something about the oath of office. Every time I go to court, you can ask them to present their oath of office. Anyone that you're going to talk to. Anyone who works for the state has to have an oath of office on file. So when you go to court, you can simply go to the court clerk and do a simple notice. You put notice on the top of the page, and then you put Open Public Records Act, or OPRA Act, and you say you require so-and-so's oath of office, and then you give it to the court clerk, and you have her make a copy of it, stamping it, giving you the original back, and they make a copy and keep it for themselves with the date stamp on it. What I do to get their oath of office. This is called OPRA request under their Open Public Records Act. You can put notice at the top of the page. You can write it differently than I did. I did this here, more of a common law style, learned from Carl Lentz. And you see here, you sign your name, print your name. You see here, that's my thumbprint. You write seal through it. You can write non-assumptive over your name. Instead of writing UCC, what, 1-308, something like that. The old code. The old, it's been changed, so you don't want to write that over your name if you know what I'm talking about. I think it's 1-308. You can write non-assumptive on top of your name. I learned this way to tell them, show them that you're living flesh and blood. And like I said, make sure they date stamp it. They had to stamp it, make a copy for themselves, and give you the original back. And then the judge should hand you their oath of office. Do it to the prosecutor too. I found one time that the prosecutor didn't have an oath of office, and he did not have insurance. You can get their whole entire file also for a few dollars for their, they want you to pay for the prints, 10 cents or something. But I'm going to end it here. This is the end of part 2. Any questions? Ask away.